Ladies and gentlemen, please welcome without any further ado our next guest, Justice D.Y. Chandrachud, former Chief Justice of India, and my colleague Kaushik Deka, Managing Editor at India Today. Thank you very much, ladies and gentlemen, once again at the Mumbai India Today conclave, where we are going to put a very simple, direct question. Does the Indian judiciary have a moral compass? Do they have a sense of constitutional morality? Is the question I want to pose to Justice D.Y. Chandrachud, who's just written a book, Why the Constitution Matters, part of his selected speeches. Appreciate your joining us here, Justice Chandrachud.
Thank you very much.
I want to start with a contentious issue raised by someone who's a member of the Prime Minister's Economic Advisory Council, Sanjeev Sanyal, who has said the judiciary is the biggest roadblock to building a Viksit Bharat. Judicial delays, failure to enforce contracts, all of which is leading to bottlenecks in the system. Do you agree that the judiciary is the biggest roadblock to a Viksit Bharat, Justice Chandrachud?
Expeditious disposal of cases is the key to the preservation of the rule of law. What does any foreign investor, or for that matter, a domestic investor, want? Certainty, transparency, and objectivity in the application of standards, and effective early disposal of disputes which come to the court. Now, that is not happening. There's no doubt about it, that we are plagued by the delays of the law. But to say that the judiciary is the biggest roadblock would not perhaps be the correct perception. Because why does this take place? It takes place first because the judiciary lacks infrastructure. Who controls the budget for the infrastructure of the judiciary? The government. Second, what is the reason for the delays? The government is the largest litigant. Who files cases in the courts quite often without justification? The government. Third, who enacts laws which add to the burden of the judiciary? Laws are not enacted by the courts. Now, I'll give you a very simple example. Section 138 of the Negotiable Instruments Act, the check dishonor cases, which have flooded our courts. So the answer to it, I'm not blaming government, I'm not blaming parliament. The point which I'm making is when new laws are enacted, particularly in the post-liberalization era, like the Insolvency and Bankruptcy Code, or specialized laws on electricity or securities or competition, a statutory or parliamentary audit has to be conducted on what is going to be the impact of these laws on the infrastructure. Now, if you build an airport, to give you a very simple example, it's not exactly on point. If you build an airport without a highway linking it to the airport which you're going to build is going to be of no consequences. So we need to build the infrastructure of the Indian judiciary. Also, create conditions by virtue of which the truly meritorious people who are trained enough to meet the challenges of our time get appointed to the courts.
So you're accepting there's a quality problem somewhere there. Quality of the judiciary is a problem because Mr. Sanyal then went on to say that judges get long vacations. Why do you need to have such a long vacation in the summer? For example, that's a colonial legacy. So there's a quality of judiciary problem. There's a question that whether, as you yourself accept that there is a judicial infrastructure problem. Do you concede that judges need to perhaps end these long vacations?
The origin of vacations is colonial in nature. But you ask any judge of the Supreme Court, what do they do during the vacations? They're not vacationing. You need the vacation to prepare judgments. That's the time when judges write judgments which are dealing with some of the most seminal issues of our time, which will impact on which way our society is going. Judging is not just a question, Rajdeep, of disposing of cases, but of reflection, of thought. You need judges who will have that ability to reflect and bear on the consequences of our judgment. But more important than that, when we say that you should scrap the vacations, well, judges would agree with it because judges can take their leave through the year whenever they can. The vital stakeholder in the system is the bar, the lawyers. Now, lawyers, whether in the states or in the Supreme Court, typically get their work from the districts. They have to go back to their districts. Many of them are very deeply connected to their roots. Unless the lawyers are on board, you will not be able to run the system.
Before Kaushik takes this forward, I just want to ask you, quality of judiciary. Would you concede that the best and brightest are not entering the judiciary? Do you concede that or not?
Yes and no. At the lowest level, that is not so. When we have competitive examinations for recruitment to the district judiciary, 70% in many states, in most states, 60 or 70% of the new recruits are women. And these are the best and brightest minds from across legal education who are entering the district judiciary. The problem arises in the higher judiciary, when you're recruiting, say, district judges from lawyers, or worse still at the level of the high courts. What's happening is that unlike when I became a judge 25 years ago in 2000, now there is an increasing reluctance on the part of lawyers to become judges. Not solely due to the difference in emolument between what a lawyer makes at the end of a week's argument in court and the salary of a judge. There are other soft perks which judges get. You have a stable salary, a pension, medical benefits, so on and so forth. The real problem which many people face is the intense social media scrutiny, the intense trolling which takes place against judges by certain segments of the polity which want to bend the independence of the court in order to secure outcomes which are favorable. Good people don't want to get into this anymore.
I'm going to come to that later, but go ahead, Kaushik.
You said good people do not want to come into judiciary, become judges. But at the same time, you have to wait till 45 years of age to become a high court judge. And then the system of appointment, which is always criticized, that opaque system of Collegium, and also judiciary blocked the government law because which was tilted towards executive. So in that process, we see a lot of appointments which are very controversial. Recently, the elevation of one judge was dissented by a Supreme Court judge, part of the Collegium. So in that case, how do you justify elevation of good individuals or good lawyers to the higher judiciary? Because along with that, there is also the criticism of nepotism. Like you were criticized when you became a high court judge at a very young age because you were a nepo kid. That was the criticism. It often comes. So it's called the uncle judge and all those things that come in. So in that context, how do you see smart, bright individuals, lawyers coming into judiciary, coming into becoming a judge?
Now let's face it. If you want to appoint a CEO to a top corporate organization in the country and you lay down a rule that you will not become CEO until you turn 45, people will say in today's times, what does age have to do with talent or merit? Now, we have laid down not constitutional principles. The Constitution does not say that. But as Kaushik just said, we have this unwritten convention which is actually part of the Memorandum of Procedure, in terms of which a High Court judge cannot be appointed ordinarily until you turn 45. Now, what does that lead to? Because people must understand that. I took 13 years of judgeship in the Bombay High Court before I became the Chief Justice of the Allahabad High Court. I spent 3 years in the Allahabad High Court as the Chief Justice, which meant that I put in 16 years before I became a judge of the Supreme Court. Now, if I was appointed only after 45, I would go to the Supreme Court at 61, leaving me 4 years to deal with cases in the Supreme Court, which is just not adequate enough. So the point of the matter is, just as India is changing, we are a country which is reaping the demographic dividend. We are essentially a young country. And why should we not apply this principle to the Indian judiciary? Recruit people when they are young. If they are good, age should not matter. If you are not good, age is in any case irrelevant. You don't take them because they are not good. The second point which you made about the opacity of the collegium. Kaushik, it's important to understand. It's great, to speak, on a television show or in an academic journal and say that there should be more transparency in judicial appointments. But when you're considering people for appointment, you're looking at everything. Their personal lives, their income, their antecedent social and other background. Do they have problem areas in their personal life? Now, if you put all of this in the public realm, the danger is that good people who are as it is shirking away from becoming judges will not even want their names to be considered. So there is this balance which you have to draw between the privacy of the individual who has been selected for appointment and the need for a certain degree of transparency. Transparency, you're perfectly right. There has to be transparency, not in terms of evaluating the merits of every candidate out in the open, but in laying down established objective criteria on the basis of which you will decide. And finally, when you asked me, whether I was one of those
Why
persons,
should that elevation be dependent on the discretion of 5 individuals or the Collegium?
Again, that is not entirely a very correct way of looking at it. The members of the Collegium in the High Court consult widely. They consult other colleagues who are drawn. For instance, when I was Chief Justice of the Allahabad High Court, I consulted all my colleagues pretty much. Asked them who are the good names, who are worthy of consideration. And then you find out details about them, their performance, their merit. How many cases have they done? Are they specialized? So on and so forth. Now, your final point about me personally, something which is really a less known fact. I was asked to become a judge of the High Court at the age of 38, which was when I was appointed Additional Solicitor General of India. And far from my wanting to continue to be in the fray for High Court appointment, I walked up to the then Chief Justice Y.K. Sabharwal, and said, please relieve me of this burden of accepting judgeship. I wanted to walk out for the reason that I had a whole lot of personal issues at home. I don't know whether I should be saying it on a platform like this. My late former wife was suffering from cancer. We had to get a house for her to live in. And if you wanted to take a loan, you had to have the money to pay for the loan. And you can do that only if you're a lawyer. So I asked the then Chief Justice to just let me be free. I didn't want to become a judge, even at that time. And ultimately, whether you're a product of a nepotist system or no, you must judge the person's work. Just don't go by these labels that someone is, connected or has some network. Look at the quality of the work which that person has done. I'm not speaking for the quality of my work. You assess it, let society assess it for themselves.
Let's turn to the question of constitutional morality. There is a general belief that in today's world, you need access to the judiciary to get speedy justice. If I am a Kashmiri Muslim who has been arrested under the Public Safety Act in Jammu and Kashmir, you will sit on a habeas corpus petition for years. And this was a charge made against your judgeship as well. After Article 370 was abrogated, thousands of people were put in jail. They struggled to get access to the court. On the other hand, if I'm privileged and I have access, the courts are always open for me. Do you agree that we have a dreadfully unequal system that reflects perhaps the inequalities of our society? If I'm a slum dweller living in an unauthorized colony, no judge is going to ever even look at me. On the other hand, if I live in Sainik Farms, which is allegedly unauthorized, but I'm influential, who knows, the judges will give us a early hearing, true or not?
Rajdeep, since your comment is anecdotal, let me give you true facts, anecdotal evidence to the contrary. When I was Chief Justice of India, I came across a case where an individual who was convicted of an electricity theft was sentenced to 2 years of imprisonment. Now, it was a conviction which was imposed after the case was compounded. Compounded means that the person accepted their guilt and he was subject to 2 years of imprisonment. Now, unfortunately, there were 9 such cases where this person was convicted. So it meant that in 9 cases, each of which he had been sentenced to 2 years imprisonment, he was sentenced to 18 years of imprisonment. For what? For electricity chori, or for, in other words, theft of some electrical power cables. I'm not belittling the offense, but certainly it's not an offense for which you should be sentenced to jail for longer than what he would get if he committed an act of murder. He never challenged it. He never, because he was too poor. He was a poor Muslim person. He never came in challenge against the conviction in any of those cases. He finally filed a petition before the Allahabad High Court saying that how can I be in jail for 18 years for theft of electricity? The Allahabad High Court said, sorry, but you never challenged your conviction. He came to the Supreme Court and we set him free. We said that, look, even though this is a solitary voice challenging the imposition of a sentence, of a total sentence of 18 or whatever years, this person must have a voice in the system. So it's, very easy to flog the judiciary by saying that, well, these are the people, slum dwellers who don't get an opportunity of being heard or whatever. It's to the contrary. You'll see, for instance, in the bulldozer demolitions case, where, bulldozers were used to demolish homes. Mine was the first judgment in the Supreme Court, where we said that, look, we are governed by the rule of law. And you cannot demolish people's homes by sending the bulldozers in without following due process.
Sir, but Kashmiri students, with due regards, have taken years to get their habeas corpus petitions heard. Even the Chief Minister, former Chief Minister Omar Abdullah was struggling to get heard by the Supreme Court.
Well, insofar as habeas corpus petitions are concerned, when I took over as Chief Justice of India, we prioritized two categories of cases. First, matters involving habeas corpus, and second, cases involving bail. And that's where I think leadership makes a difference. Because ultimately, the leader of the institution, be it a High Court or the Supreme Court, has to lay down the priorities for the system.
Justice Chandrachud, I'm sorry to intervene, because even on bail, you were accused of sending most of the bail petitions to a particular judge, Justice Bela Trivedi, who was known not to give bail. And therefore, as master of the roster, you were accused of actually preventing people from getting bail. Umar Khalid being a classic example.
Well, Rajdeep, it's very well to make this general unsubstantiated allegation. The facts are to the contrary. When I was Chief Justice of India and I said we prioritize bail, in the 2 years that I was the Chief Justice of India, we granted bail in 21,000 cases. Over 21,000 individual citizens of India got bail. And when you say that, well, a particular individual didn't get bail, I've been on record to say that, well, in my court, A to Z got bail. Every single individual who deserved bail got bail.
You did not get bail. You.
Just a second. If you didn't get bail, 1 second, it was not my courtroom. I'll deal with that issue about Justice Bela Trivedi that you raised. But are you aware of a P? Pawan Kheda? Pawan Kheda was sought to be arrested as he was boarding a flight. Right? Kaushik, you belong to that part of the country at Guwahati?
Yes.
His lawyer comes to the Supreme Court at lunchtime and mentions that my client is being arrested because he said something distasteful. Let's not make any bones about the fact that what Pawan Kheda said was distasteful. I mean, Dr. Singhvi himself, when he made that case, said that I don't stand by my client's statement. My point is, this is not a case for arrest. Who protected him? The Supreme Court protected him. Second, your assessment that all cases of bail were assigned to Justice Bela Trivedi is factually incorrect. Cases involving bail are dealt with by every single bench of the Supreme Court, for the reason that the largest inflow of cases into the Supreme Court are criminal cases. So every single judge of the Supreme Court deals with criminal cases, which are allotted on a random basis by computer. What happens is that suppose, Rajdeep, you and Kaushik are in the bench, right? And you retire. And then Kaushik joins me in the bench. Kaushik retires. After you retire, the case will be attached to Kaushik. After Kaushik retires, it will be attached to me. That's the way the Supreme Court really functions.
Kaushik.
These are well-established conventions. Let's not make a grievance about one case into an issue about the system.
Okay.
The facts of the system are very, very different. On an individual case, Rajdeep, you may have a difference of opinion as to whether someone should get bail or otherwise. The last thing which I want to say is, we have in India the presumption of innocence, which is to say that an individual is presumed to be innocent unless he or she is proven to be guilty. And that means that ordinarily bail should be the rule, jail should be the exception. Equally, we have well-established principles. Is this individual likely to tamper with the evidence if they are released on bail? 2, is this individual likely to flee from justice if that individual is granted bail? Just as individual personal liberty is involved in the grant or refusal of bail, equally, there is a societal element in prosecuting crime. So very often we just ignore the element of societal interest in the prosecution of crime, which is equally important, because you don't want our streets, you don't want our communities to be unsafe for individuals. So the work of a judge is not simple by any means, because you're drawing this balance from case to case. Whether the balance has been drawn correctly in a case or not, by all means, we are free citizens of a free nation. You're entitled to your freedom of speech and expression. But let's not tarnish the system on the basis of unsubstantiated facts.
Okay, let's move to constitution now. You often talk about the importance of constitution. There is a basic structure of the constitution, and if I am not wrong, you also mentioned about it. Now, from when do we start this basic structure of the constitution? From the time it was adopted? From the time it was adopted? Or from the time these two words were added to the preamble, secularism and socialism? Because if we go by the fact, if you say that it should be, the basic structure should be from the time it was adopted, then this insertion of these words, even if by the parliament, is a violation of that basic structure, logically. I'm not debating about the two words, but so how do you see the basic structure of the constitution? Because one former Supreme Court judge has also said that we need to debate actually the basic structure of the constitution.
Kaushik, the answer to your question is very simple. When a court, especially the Supreme Court, declares the law, the declaration of the law, insofar as the Constitution is concerned, goes back to the inception. Unless the Supreme Court says that the declaration of the law will be prospective. So the Supreme Court can today say that, well, we are ruling this to be the legal position, but it will take effect from 1st of October 2025, in which case it will have prospective effect. Otherwise, the general principle of law is that any declaration of law is always retrospective. And insofar as the high courts are concerned, they have no power of prospective overruling. So to answer your specific question, once in 1973, 1st of April 1973, if I'm not wrong about the date, the Supreme Court in Keshwanand Bharati's case said that there is something called the basic structure of the Constitution. What is the basic structure? Democracy, equality, liberty, fraternity. Once that was said, that is a defining feature of the Constitution as it was originally adopted. The concept of basic structure, in other words, will not be with effect from a much later date. But to my mind, it defines the original features of the Constitution. Otherwise, look at how absurd it would be. Can we say that because democracy was inserted in the Constitution before 73, democracy is not a part of the basic structure? Obviously it is. Equality. Article 14 was always a part of the Constitution. Can we say that that's not a part of the basic structure? Obviously it is a part of the basic structure. So the question really answers itself.
Of course. So you mean to say, Justice Chandrachud, because these two words were inserted much later, even after 1973, so these two are not actually part of the basic structure? Secularism and socialism?
So you see, there again, as in the law, you must always understand the nuance. Is the insertion of a word in the Constitution, does the insertion bring about a change in the legal position for the first time? Or is the insertion a recognition of the position as it already existed in the Constitution? Now, one way of looking at it is this, that the Constitution, when it was originally adopted, by the Constituent Assembly, and then brought into force in 1950, the Constitution always spoke about the equality of faiths. The Constitution always spoke about your freedom of conscience. So one way of approaching it, in fact, I have said it in one of my judgments, that is to say that the Constitution as it was originally enacted postulated this fundamental pluralism of our society, the need for inclusion, a recognition that we are a multicultural, multi-religious, diverse society. And there are various provisions of the Constitution which give vent to this particular doctrinal position. Once you accept that, then a particular insertion may be only a recognition of a position as it obtained. Now, secularism, as you know, came in as a result of the 42nd Amendment, which was the emergency amendment. There are two views. One way of looking at it is, well, it was brought in 1976. The contrarian view is, but it's just a recognition of what the Constitution always assumed as a fundamental principle.
Okay, I
Actually,
just
no,
want
I
to
have
bring.
a- I have a
I just
follow-up
want to bring a
question.
photograph. We have just 4 minutes. I want to bring a photograph because I want to look at your personal compass. One thing is the judiciary's compass. Take a look at this photograph because it caused controversy. Looking at that photograph, critics of you, because you mentioned social media, immediately said, Justice Chandrachud has set a dangerous precedent blurring the lines between the judiciary and the executive. How do you respond? Narendra Modi ji coming for a puja at your house, all of it photographed. Do you believe it set a dangerous precedent blurring the lines between the judiciary and the executive?
Rajdeep, there were two criticisms of people who criticized. The first category of people had a problem that I openly accepted the fact that I perform a puja. I make no bones of the fact that I'm a devout Hindu, that I'm committed to my faith. But interestingly, let's not forget that the oath which a judge of the Supreme Court takes, the oath begins by saying, I do swear in the name of God that I shall bear true faith and allegiance to the Constitution of India as by law established, or you, of course, solemnly affirm. So our Constitution is not agnostic to religion, nor is our Constitution opposed to religion. That's the first.
Yeah. The second.
The second that I want to postulate is this. Though each of us as judges are entitled to believe, pursue our own faith, whether we are Hindus, Buddhists, Jains, whether we are Sikhs, whether Zoroastrians, the justice which we do is even-handed among communities. Every single day, if you look at the cause list of any court, you will have communities across the board seeking justice, to whom even-handed justice is delivered. Third, and the third point which is about the Prime Minister coming to the residence of the Chief Justice. If people have an objection about the Prime Minister, well, this was an easy handle to target the Chief Justice for inviting the Prime Minister. Between constitutional functionaries, let's have an element of how we are not leaders of opposition parties. The judiciary and the executive, the Chief Justice of India is not the leader of the opposition. Of course, in the work which we do, we are independent of the executive. The Prime Minister visits the homes of judges when there is a marriage in the family. When my mother passed away in 2014, January, when I was in Allahabad, the Chief Minister of Uttar Pradesh then came to my house to visit me with his wife, just the four of us. So these are elementary courtesies of constitutional office. They have nothing to do. No. And the ultimate test, Rajdeep, is this. How is that person performing as a judge?
But that precisely is the question. The context of this was the judgments you gave, many of which were politically loaded. Article 370. You effectively endorsed the government's decision to repudiate Article 370. Then came the Ayodhya judgment, where you, on the 5-judge bench, was accused by critics again on social media and lawyers and jurists of putting faith above law. You yourself, in October of last year, said, I prayed that I would get the right judgment. You now, in a recent interview, have gone on to say that the original act of desecration was the erection of a mosque, effectively suggesting mosque was built over a Ram temple, something that your Ayodhya judgment doesn't say. There you leave it open. Now, after retirement, you're saying that the original act of desecration was the erection of a mosque. Now people are saying Justice Chandrachud is showing his Hindutva colors. That what you didn't say in the judgment, you're saying now openly, and thereby giving a Hindu viewpoint. You yourself, sir, in the judgment said the act of December 6, 1992 was a criminal act, and yet go on to give the title to the very group which was accused of committing the criminal act. So therefore, that's the problem. That's social media.
Before you answer, I want to add one question to that.
Can I just answer this question and then take
No,
the second
same
question?
Same
All right.
question.
But then you have to leave me a little time for the answer.
Because you just mentioned about secularism, so you have admitted that it was actually a title suit. It was a land dispute, Ayodhya case. So in a land dispute, you also went on public saying that you prayed before the verdict, means you, so that it helps you. So my question is, do you pray every time you settle a land dispute to your God, or in a secular country, by publicly publicly revealing that you prayed, did you not violate that basic structure of the Constitution?
Let's start with the first question, then the second.
All right, I'll answer the first question. I'll answer the first question first. First and foremost, you have put the entire context of the judgments that, well, we had decided Ayodhya, that we had decided Article 370. You know, Rajdeep, what's happening is this. In the age of social media, we are now so divided. And the perception of people in the social media is, unless you decide every single case along the ideological lines to which I means a person in the social media subscribes, if you decide every single case in favor of that ideology, then you are independent. Independence is also defined as only deciding cases against the government. So this is the definition of independence in the social media. The moment you decide a case against an ideology which is portrayed by a particular element in the social media, then you cease to be independent, you are pro-government. Now please bear in mind that just as one or two cases were, as you said, you know, they ended in a decision in favor of the government. On the other hand, I can give you example after example. First, the striking down of electoral bonds as unconstitutional. That happened just about the same time against the government. We struck down the electoral bond scheme as lacking in transparency. Two, was Aligarh Muslim University entitled to minority status? We reversed a judgment of our court of the 1960s and came to the conclusion that the judgment was wrongly decided. In the battle between the National Capital Territory versus the government, 2 consecutive judgments of the Supreme Court Constitution benches holding against the government. Parliament thereafter enacted the law, which the validity of which is under challenge. Speaking for myself, the dissent in the Bhima Koregaon case against the government. Aadhaar, I was the sole dissenter in the Aadhaar case. So I wanted to say this to you, and I'll go immediately to the latter part of
but
the
But you haven't answered. Original act of desecration was
that.
the erection of the
Just
Babri Masjid. Why didn't you say that, sir, in your Ayodhya judgment?
1 second. Give me an opportunity to answer. It can't be that, you know, it'll be a monologue from your side without giving me an opportunity to answer. Unless like lawyers or the social media, you're carrying a brief which you want to espouse before your audience.
No, I want you to clarify. I want you to clarify the position because you're trending on Twitter because of it.
The point of the matter is that when you don't give an opportunity to someone who's being questioned to answer,
sir, please.
And that's exactly my grievance with the social media, that you must hear an opposing viewpoint, which you must
So
hear.
explain that statement.
Right. Now, insofar as Ayodhya is concerned, what did I say? And what have we done in the judgment? This was a title dispute. What came to the Supreme Court was a first appeal against a claim on title. And we decided that on well-settled principles of adverse possession. Could the Muslim side assert that they were in adverse possession of the land and therefore they could perfect their title? Which we held against them. At the same time, we allotted 5 acres of land to the Muslims, just as the land was given for the purpose of construction of the Ram temple. Now, answering the latter part of both your questions, which is crucial, and I'm happy that you've given me the opportunity to do that. The fact is undisputed that every single day that you enter a court, you're entering upon a zone of intense conflict. Now, speaking for myself, and I take that not something which is exceptional, but judges across the system. What is wrong about the fact that to bring a sense of peace, equanimity, and equilibrium in the work which you do as a judge, you pray every morning or you meditate every morning, please allow me, and you may pray to a deity, you may pray to a broader spiritual force, irrespective of your religion. Please allow me that sense of equanimity so as to enable me to do justice with an even hand. I must also share with you that when I climbed the 3 or 4 steps of the Supreme Court to the Judges' Court and later the Chief Justice Court, I said the Navkar Mantra. I'm not a Jain by religion, but I would say the Navkar Mantra every single day. And what was the purpose of it all? So just, when I was Chief Justice of the Allahabad High Court, I went to a very sacred dargah near Barabanki. Now, I'm a Hindu, I'm a devout Hindu, but my religion allows me to pray across religions. When I go to Goa, the first place that I always visit is the church in Old Goa. So this is the broad diversity of my own faith, a faith which accepts the fact that just as I believe, I must have faith in other people's right to believe and to respect their faiths. So I don't think there's anything wrong in doing what I did every single day of my life as a judge, namely spending my moments in quiet reflection and prayer in the morning, so that the work which I do as a judge, work which is in a zone of intense conflict, does not end in injustice to anybody. The Constitution allows me to do it. Our Constitution protects the right of every judge to be a believer. And if I said that, I don't think that made any difference. That question which you asked me at the end on what I said in the course of an interview, I think what has been done is, like again something in social media, that you lift out of context one part of the answer and then take another part of the answer. During the course of the same answer, I answered whoever the interviewer was the other day by telling him that the entire case has been decided not on the basis of faith, but on the basis of adverse possession. Read the judgment. And the problem is most people who attack us don't have the time, the patience, or the inclination to read 1,045-page judgment. Why was it 1,045 pages? Because the record was 30,000 pages in Ayodhya. People who don't read the judgment attack you because it's very easy to attack judges, right? I mean, you flog them on social media.
Do you want to tell us, did you write the judgment? Nobody knows who wrote the judgment. The general buzz is you wrote the judgment, true?
Rajdeep, I'm a disciplined soldier of the system. All of us took a decision that this was a dispute which had driven our society for hundreds of years, that we will speak with one voice to the nation. And that's the reason why we have not attributed authorship. Whether in office or in retirement, I maintain that I have to be disciplined as a judge.
One question about impeachment, judicial accountability. So we saw 2 cases of impeachment, 2 applications of impeachment were in Parliament. One was almost fast-tracked, and the other one, no action has been taken on this. Why I'm asking you this question, in both cases, you were directly, indirectly related, in a sense that when Justice Yashwant Verma's case came in, many people in the judiciary and on social media, there are inferences that he was close to you. And in the second judge's case, when his elevation happened, you had actually flagged his political affiliation. Now, how do you see this? Parliament fast-tracks one impeachment and the other Parliament is not taking any decision, particularly the Speaker. So how do you see this difference? Is it political or is it... And in fact, the impeachment where action has been taken, the way it has been done is also legally questioned.
Kaushik, the problem with your question is that your question always contains an innuendo.
Yes,
so I have to deal with the innuendo just as I have to deal with the question.
Yes.
Now, the innuendo...
I wanted you to be clear because innuendos flow and you don't get a chance to speak.
Right. The innuendo... I have been in the Indian judiciary for 25 years. As a judge who is deeply committed to the system, I mentored generations of judges across India. I was part of the Collegium, which was part of the decision-making process in which Justice Yashwant Verma was transferred to the Delhi High Court. I happened to be the Chief Justice of the Allahabad High Court, a court where he was himself serving. But so also a large number of other judges. Justice Vikram Nath, who is one of the senior most judges here, was my colleague in the Allahabad High Court. Justice Manoj Mishra, who has come now to the Supreme Court, was my colleague. Justice Pankaj Mittal, who is a judge of the Supreme Court today, was my colleague. So what is the innuendo about, somebody being close to someone? That's the first point. Second, which is the more fundamental point which you have raised, on which there's a grain of truth and substance in what you are saying. Once a motion of impeachment is placed before the Speaker by the requisite number of members of Parliament, then to my mind, whether the motion of impeachment deals with Judge A or Judge B or Judge C, you must apply even-handed yardsticks. And that is my firm opinion. In other words, you cannot make a distinction between motions of impeachment by applying varying standards. Because ultimately we are dealing with the institution of the judiciary, its credibility, its legitimacy. And I think it's important, therefore, that any process for bringing accountability to the Indian judiciary must be even-handed in the standards which we apply across the board.
You targeted the media briefly there, saying you don't give us a chance to answer. And as a judge, that's a difficulty because there's only so much you can say while you're a judge. But you found after retirement even more questions being thrown your way, including a controversy over why has Justice Chandrachud overstayed in the Chief Justice's bungalow. It became a headline story. Do you want to give an explanation on that? You're now in a better position than if you were a judge. Again, you were, in a way, being accused without perhaps being given your side of the story. So I want to hear, why did you overstay?
Thank you so much, Rajdeep, for this question. Rajdeep, Kalpana and I are parents to two special needs children who are our adopted daughters.
Yes.
The hard fact which I realized after I retired was of accessibility. You do not have homes, even in a place like Delhi. What about other cities where you could have access to children who are in a wheelchair? One of our daughters is connected to a tracheostomy tube and a BiPAP machine. Both the children are on wheelchairs. And we found that there are no ramps. If there is a ramp, the lift, there's no lift thereafter to go to the first floor or the second floor. Even within homes, within flats in Delhi, bathroom doors are not wide enough for a wheelchair to enter, for a special needs child to use the toilet. This is the hard fact, Rajdeep. And this was something which I pointed out to the then Chief Justice, that I need 2 more months for me to find suitable accommodation. For those 2 months that you overstay, the government has a standard schedule of rates, market rent, for which you have to pay the government. But surely, I do expect that after 25 years of having served the nation, 2 months, particularly when neither of my successors were going to occupy the home of the Chief Justice of India, this is not too much to ask.
Okay,
but he not only, the CJI not only shamed you in public by writing that letter, also he took dig at you in public events, mentioning about that he would vacate it and congratulating another judge that you have vacated it very next day after your retirement. How do you see that? It's a personal attack.
Kaushik,
One CJI to another.
Kaushik, my philosophy of life is this.
1 minute more.
Life is finite. There's so much of good that we can do through our life and the time that we have as human beings. Why look at the negatives and respond to negatives, So I always look at the positives.
Okay, I'm going to end. As we end, you've had a long, illustrious career as a judge. You gave important judgment. Let's look at the positive. You gave important judgments, and I think you deserve a huge applause for decriminalizing homosexuality, Article 377. You deserve a lot of applause for right to privacy and your judgment that you gave on that. We may question your political judgments, but there were important judgments that have had important effects on society. After such a long career, which is that judgment you are most proud of, Justice Chandrachud? The positive. Let's look at the positive.
Okay. If you ask me the same question tomorrow evening, I may have a different view because you think about your answer, because there's so many judgments which came my way. But honestly, the one judgment of which I'm truly, truly proud is of getting women as permanent members of our armed forces. Because when I find a woman, as a fighter pilot on our Rafale jets or a Sukhoi, or a woman on the border guarding our lives and our nation, or a woman on a submarine or on a warship on high seas defending India, I feel that's what my deed has done for the nation.
But unfortunately, sir, in Supreme Court, the number of women judges are still not adequate.
Yes, can I just answer that in 30 seconds? As I said, at the lowest levels today in the district judiciary, about 60 to 70% of the new recruits are women. Why? Because legal education today has become extraordinarily broad-based, with women entering into the legal profession. The state of the Supreme Court today reflects the state of the legal profession, say, 20 years ago, when women who are now eligible join the legal profession. Unfortunately, that's how we climb up the ladder, right, to be eligible for appointment to the Supreme Court. You can't just appoint a woman who is, say, serial number 950 in the All India list of seniority and appoint her to the Supreme Court merely because you want a Supreme Court judge. These are some of the problems of service, because you also have men judges who've spent their lives in service of the institution. But I dare say now, with more and more women leading very successful careers in the law, the time is ripe now that these are women who are going to occupy important judicial offices in the future.
I think we've gone through a wide range. We have a very special discussion also coming up. We've gone well over our time. I also want to tell the audience, we had Aditya, I should tell Justice Chandrachud, we had Aditya Thackeray here earlier today, and Aditya Thackeray said, please tell Justice Chandrachud, his Supreme Court decides on stray dogs cases immediately, but when it came to the symbol case between the two Shiv Senas, they have not decided it. This is the problem with our judiciary. They do not address the real issues, the real tough questions of our time. You have 10 seconds. You want to tell Aditya Thackeray?
Yes, of course, I have an answer to that. Though it's after I left the Supreme Court. The point of the matter is this. The stray dogs matter came up as an interim matter before the Supreme Court. No Supreme Court judge can say that I will not decide a case even at the interim stage. You cannot duck questions. So the Supreme Court dealt with a case of, the stray dogs by passing an interim order. The case which you are referring to, Mr.
The symbol case,
the
election
symbol case. The symbol case is a final hearing which requires time. Now there are now 80,000 plus cases which are pending before the Supreme Court. You have 34 judges, all of whom dispose of close to 70,000 cases in a year. Our judges are not unemployed. They are working to the best of their ability every single day of their lives. Now, for every case which you take up, someone else is going to say, why didn't you take up my case? Are these not important? Okay. If you take up an old case, you're told, why didn't you take a new case? If you take a new case, you're told, why didn't you take an old case? Allow a degree of understanding about our institutions. Unless we do that, institutions are bound to collapse.
We have a panel coming up of some of India's top film stars in a moment. You have a favorite film to end with. Which is the film that you like watching? Is there something that Justice Chandrachud likes watching? How do you relax? Music, film?
I relax with reading, music, watching films, of course. I've a film which I loved beyond anything else recently was 12th Fail. And the other film which I really loved was Lapata Ladies. So, two of my favorite films. And the third which I loved because of, my special daughters, our special needs daughters, was Sitare Zameen Par. And
okay. I know how much you care about your daughters, and often because we ask you all these hard political questions, the human side gets left out. Maybe one day we'll ask the human side also to Justice Chandrachud, and how he has truly raised these wonderful young daughters who now paint so beautifully and do so much else. Justice Chandrachud, for having answered all our questions, the tough ones and the soft ones. The problem is on Twitter, they'll pick up the soft ones and say you've been very soft with the judge. The others will pick up the tough ones and say you are batting for one side. That's the way we live, a very polarized, hyper-polarized world. but for joining us here today at the India Today Mumbai Conclave, taking us through all your questions. Kaushik and I truly appreciate your time.
Thank you very
much, ladies and gentlemen. Please give a big hand to Justice
Thank you
Chandrachud.
very much.